Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I'm your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. Let us begin with the headlines and a concise overview of the top stories, and after that we will delve into the full details. The Kerala High Court has sought centre's response over non-disbursal of relief funds after the Wayanad landslides. A Kerala court has directed police to investigate CM Pinarayi Vijayan's remarks on Youth Congress protest during Nava Kerala Sadas. The Delhi High Court has said that legal internships do not amount to active legal practice. The Uttarakhand High Court has issued press note on steps taken for jail reforms in the state. In a motor accident claims case, the Jharkhand High Court has upheld 50 lakh compensation to kin of the deceased lawyer. And the Enforcement Directorate has told the Bombay High Court that it will not be acting on eviction notices against Shilpa, Shetty and Kundra till their plea against provisional attachment is decided. The Kerala High Court today sought response from the central government regarding disbursal of funds for disaster relief in Wayanad while hearing the suo motu case initiated after the deadly Wayanad landslides. The division bench comprising Justice A.K. Jayasankaran Nambiar and Justice Shyam Kumar V.M. had previously noted that the National Disaster Management Response Fund and the Prime Minister's Relief Fund had not released any amounts for disaster relief to the state of Kerala after the disaster. It was also noted that neighbouring states like Tamil Nadu and Karnataka have received allocations from the State Disaster Management Response Fund and the NDRF. Today, the Additional Solicitor General ARL Sundareshan sought time till 18th October to obtain instructions from the Centre and NDMA. Meanwhile, the government filed a statement detailing lands that are suitable for resettlement of affected people. The court orally told the ASG, and I quote, "Get some positive action from the central government because we need to get Wayanad back on rails as soon as possible." At this juncture, Advocate General for the state K. Gopal Krishna Kurup submitted that centre is also to take a decision regarding writing off loans of the landslide victims. Let me tell you that Section 13 of the Disaster Management Act 2005 empowers NDMA to recommend relief in repayment of loans in cases of disasters of severe magnitude. This aspect will now be considered by the court next week as the matter has been posted to 18th October. The Ernakulam Chief Judicial Magistrate has directed the police to conduct investigation into the speech made by Chief Minister Pinarayi Vijayan in Nava Kerala Sadas in November 2023. Reportedly, some members of the Youth Congress Party were attacked on 20th November 23 in Kannur for showing black flags against the Nava Kerala Sadas bus, which was carrying the Chief Minister and other ministers. On the next day, when the Chief Minister was asked about the incident, he reportedly said that they were only pushed away from the road to prevent an accident. He is also said to have added that what was done was imitable and such methods should be continued. Mohammad Shias, the president of Ernakulam District Congress Committee, moved the court seeking action against the Chief Minister for the statements made in the speech. He alleged in the complaint that the speech was provocative and further enraged members of various parties like DYFI and SFI to attack Youth Congress members. The petitioner submitted before the court that he had complained this matter before the police, however, no FIR was registered. He also said that he lodged a complaint with the Commissioner of Police of Kochi, after which he approached the court. In the next update, the Delhi High Court has observed that legal internships undertaken as law students do not amount to active legal practice after being enrolled as an advocate. The court made the observations while dismissing a plea by a lawyer seeking inclusion of his name in the list of shortlisted candidates for an upcoming interview for empanelment of the jail visiting panel. He enrolled as an advocate in August 2021. In June 21, the Delhi High Court Legal Services Committee had issued a notice inviting online applications for empanelment of advocates and mediators for different panels. He submitted an online application for the empanelment, but his name was not included in the shortlist of candidates. Upon oral inquiries, he found that his application might have been rejected due to not meeting the minimum experience requirement of 3 years of legal practice as of 31st May, the cutoff date. He submitted that he had actively interned during his law school with various lawyers over a substantial period of time, and thus his internship experience should be included for fulfillment of the eligibility criteria of 3 years, which would make him eligible for participating in the interview process. But Justice Narula rejected the contention of equating the terms internship and apprenticeship, which suggested that the internship experience gained before being formally enrolled as an advocate should be treated as equivalent to an apprenticeship under legal terminology. Justice Narula observed that internships undertaken as part of legal education, though valuable in providing practical exposure, do not satisfy the professional experience requirement for practicing law. The court noted that certain government bodies also engage services of law graduates as apprentices in their legal departments for a stipulated time, but such opportunities are available to people who have graduated with a LLB degree. Therefore, to equate a law student's internship with post-enrollment practice would blur the distinction between academic training and professional legal expertise. Therefore, the plea was dismissed. The Uttarakhand High Court has released a press note highlighting significant steps taken towards implementing crucial judicial reforms in the state through PILs aimed at providing equitable treatment to prisoners following the constitutional mandate enshrined under Article 21. Through 2 suo motu PILs and an ongoing PIL, the court led by Chief Justice Ritu Bahari and Justice Rakesh Thapliyal has initiated key changes aimed at improving the welfare of inmates. The first major achievement is reduction in death reference cases, with none pending in the High Court. The court also addressed the issue of prisoners eligible for premature release. Of 204 convicts, 145 have already been recommended for or ordered to be released. The second suo motu PIL highlighted the overcrowding in Nainital District Jail, pushing the court to demand a status report on under trials unable to secure release due to non-functioning bail surety bonds. As a result, 2,500 trials have been released on personal bonds. Lastly, the court has also called attention to unfair labor conditions in jails, directing the state to consider equitable wages for prisoners working under rigorous conditions. The Jharkhand High Court has dismissed an appeal filed by Bajaj Alliance General Insurance challenging an award of 50 lakhs in compensation to the family of a deceased lawyer who was killed in a road accident. Justice Subhash Chand reaffirmed that non-compliance with permit regulations does not constitute a fundamental breach of an insurance policy. Let me tell you, the deceased lawyer was fatally injured in an accident near the Baura taxi stand when a tempo collided with him. An FIR was lodged against the tempo driver, citing rash and negligent driving as the cause of the accident. At the time of his death, the deceased was 34 years old and left behind his wife, 2 minor sons as well as his parents. The Motor Accident Claims Tribunal, after considering the submissions, awarded around 50 lakhs to the claimants and directed the insurance company to recover the amount from the vehicle's owner. The insurance company, aggrieved by this award, filed the present appeal. The court observed that under Motor Vehicles Act, the investigating police officer is required to prepare an accident information report within 3 months and submit it to both the claims tribunal and the insurance company. However, in this case, there was no compliance. The FIR was lodged 20 days after the incident against unknown persons. During the investigation, 2 eyewitnesses testified that the accident occurred due to rash driving of a tempo. While the delay in filing the FIR raised doubts, the court ruled it was not fatal to the claim. The investigating officer later filed a charge sheet against the driver but did not inform the tribunal or the insurance company. The court observed that it is a settled principle that in motor accident claim petitions, the strict rules of Evidence Act, CPC, or Criminal Procedure Code do not apply. Additionally, the standard of proving a case beyond reasonable doubt, which is applicable in a criminal case, is not required in motor accident claim petitions, where the burden of proof is based on preponderance of probabilities. The court thus upheld the tribunal's decision to direct the appellant insurance company to pay and recover the compensation. And lastly, the Bombay High Court bench of Justices Revati Moite Dere and Prithviraj Chavan today heard the petition filed by Bollywood actor Shilpa Shetty and her businessman husband Raj Kundra challenging eviction notices issued to them to vacate their residential house in Juhu and their farmhouse in Pune. The couple has been facing action since 2018 when the Enforcement Directorate lodged a case against one Amit Bhardwaj in the crypto assets Ponzi scheme case, where Kundra couple allegedly duped investors of over 6 crores in the form of bitcoins. The petition sought to quash and set aside the eviction notices, saying that the couple had been cooperating with ED and attended to all the summons sent to them. Today, the Enforcement Directorate told the court that it will not act upon the eviction notices issued to the couple till their plea against provisional attachment is decided. As a result, the bench decided to dispose of the petition. For more details on the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.